The room didn't erupt. It didn't gasp. It didn't even whisper. What stopped everyone cold was the pause. A pause that lingered just long enough to make it clear something had shifted, not in the headlines, not on social media, but inside the courtroom itself. The place where stories stop being stories and start becoming evidence. This was not supposed to be that kind of day. Before we continue, please hit the like button, subscribe to the channel, and turn on the notification bell for updates. On paper, it looked familiar. Another morning at London's High Court. Another appearance by Prince Harry. Another chapter in a legal fight that has followed him across continents and calendar years. But by the time the judge looked up from the bench, something had already gone wrong in a way that wouldn't be captured by a single quote or a dramatic still image. And that's the thing worth sitting with. Because this case isn't unraveling loudly. It's unraveling quietly. For years now, Prince Harry has framed his conflict with the British press as a moral battle. A struggle against intrusion, against excess, against a media culture he believes crossed lines again and again, not just professionally, but personally. That framing has worked outside courtrooms. It's resonated in interviews, documentaries, speeches, even best-selling memoirs. It has shaped public sympathy and hardened opinions on both sides. But court is different. Court doesn't respond to narrative momentum. It doesn't reward conviction. It doesn't care how many times a story has been told, only whether it can be proven, line by line, under oath. That reality is what walked into the courtroom with Prince Harry this week. He returned to the High Court as part of his lawsuit against Associated Newspapers, the company behind the Daily Mail and the Mail on Sunday. The allegation is serious. That journalists and investigators working for the publisher illegally gathered private information. Phone hacking, surveillance, deception, tactics that, if proven, would represent clear violations of the law. Associated Newspapers, for its part, has not hedged. It has vigorously denied the allegations. Not in vague language, not with careful qualifiers. Flat denials, delivered with legal confidence. So what we're watching here isn't a celebrity clash or a media circus. It's a credibility contest. And credibility, once questioned in a courtroom, doesn't bounce back easily. From the outside, it might be tempting to ask, why now? Why does this particular phase of the case matter so much? After all, Prince Harry has been suing tabloids for years. He's spoken about press abuse endlessly. None of this is new. But here's the difference, and it's a critical one. This time, Harry isn't just a claimant represented by lawyers. He is a witness. He is under oath. He is being asked not to summarize his experience, but to anchor it in dates, documents, specifics, to translate emotional certainty into legal clarity. And that translation is proving difficult. The early signs were subtle. You wouldn't catch them in a headline. A slightly longer pause before an answer. A phrase repeated too often. A careful retreat into "I don't recall" when precision was required. None of that is unusual on its own. Many witnesses struggle with memory under pressure. But memory is not a side issue in this case. Memory is the case. Harry's allegations hinge on whether he can show not just that he felt intruded upon, but that illegal methods were used, and used knowingly, to obtain his private information. That requires more than belief, more than suspicion, more than hindsight. It requires evidence. And this is where the atmosphere in the courtroom began to change. Judges are trained listeners. They hear not just what is said, but how it's said. They notice patterns, repetition, evasion, overconfidence, uncertainty masked as certainty. The courtroom doesn't reward performance, it strips it away. By the end of the first session, there were already signs that the judge was not fully satisfied. Not hostile, not dismissive, but alert, focused, engaged in a way that suggested concern rather than curiosity. That distinction matters. Because when a judge becomes concerned, the rules of engagement tighten. Questions get sharper. Patience thins. The margin for narrative drift narrows. And that's before we even get to the moment that would later be described, quietly, cautiously, as a warning. What makes this moment especially charged is who Prince Harry is outside that room. A royal who stepped away from royal duties. A public figure who has made transparency and accountability central to his identity. Someone who has repeatedly said he wants truth, not revenge. So what happens when the truth is questioned? What happens when the authority in the room isn't a palace, a publisher, or a production company, but a judge whose only allegiance is to the evidence in front of them. This is the emotional contradiction sitting at the heart of the case. Prince Harry is used to being believed. Court demands that he be proven. And there's another layer here, one that's harder to talk about, but impossible to ignore. Legal teams don't panic publicly. They don't show their cards. They don't telegraph concern unless something has shifted behind the scenes. And yet, as the days progressed, there were signs, small, controlled, unmistakable, that this team was recalibrating in real time. A change in tone, a pause where there hadn't been one before, an intervention that felt less strategic and more protective. That doesn't mean the case is collapsing. It doesn't mean the allegations are false. But it does suggest that the path forward is no longer as straightforward as it once seemed. And that's where this story becomes uncomfortable, because it raises questions that don't fit neatly into talking points or tribal loyalties. What if harm was real, but proof is incomplete? What if wrongdoing occurred, but not in the way it's being alleged? What if years of certainty run headlong into the blunt mechanics of the law? Those questions don't accuse. They don't absolve. They linger. The public often treats court cases like verdict machines, as if the only thing that matters is who wins and who loses. But long before any ruling is delivered, damage can occur. Reputations shift. Narratives bend. Confidence erodes. And sometimes, the most consequential moment in a trial isn't the verdict at all. It's the warning. A warning isn't a punishment. It's a signal, a judicial line in the sand, a way of saying, tread carefully from here, because the room is no longer inclined to indulge ambiguity. By the time Prince Harry is expected to return to the witness box later this week, that warning will hang over every answer, every pause, every attempt to clarify or retreat. This isn't about catching someone in a lie. It's about determining whether a story that is held together in public can withstand the precision of legal scrutiny. And the unsettling truth is this: not all true stories survive court. Some fail because they're exaggerated. Some fail because they're incomplete. Some fail because the burden of proof is simply too heavy. So as this case moves forward, the question isn't just whether Associated Newspapers did something illegal. The question is whether Prince Harry's long-running battle with the press, a battle that has defined his public life, can be translated into something the law recognizes as fact. Because once that translation fails, even partially, the consequences ripple outward. And when the judge finally spoke, not loudly, not angrily, but with unmistakable firmness, it became clear that the next phase of this case would not unfold on Harry's terms. What happened next would expose just how fragile control can be when the courtroom stops listening politely and starts listening critically. Human authenticity requirement. The writing must feel unmistakably human-written. Avoid symmetrical sentence patterns, formulaic transitions, or overly polished academic cadence. Use natural hesitation, subtle reframing, uneven pacing, and occasional unfinished thoughts. Allow controlled ambiguity, reflection, and restraint. The tone should resemble a seasoned journalist thinking out loud, not an AI delivering a script. Write as if the narrator is processing the information in real time, choosing words carefully, occasionally pulling back, and letting implications linger rather than explaining everything. The warning didn't come with a raised voice. That's what made it land. It arrived calmly, almost clinically, the kind of tone that tells you the speaker isn't emotional, isn't improvising, isn't bluffing. The judge didn't lean forward, didn't gesture, didn't editorialize. He simply clarified what the court required and what it would no longer tolerate. And in that moment, the atmosphere changed, because everyone in the room understood what a warning like that really means. It's not discipline. It's not punishment. It's a recalibration of power, a quiet reminder that this space does not belong to narrative or reputation or even history. It belongs to precision. Prince Harry looked up, not startled, not angry, but alert in a way that suggested he knew the ground beneath him had shifted. This was no longer a sympathetic audience nodding along to familiar grievances. This was a court asking him, gently but firmly, to stay within the lines. And that's where Chapter 1 truly begins. Because until this point, the case had been moving on a kind of inherited momentum. The assumption, spoken or unspoken, that the allegations carried weight simply because of who was making them and how long they had been circulating. Years of public discussion have a way of creating gravitational pull. They shape expectations before a single piece of evidence is examined. But courts are designed to resist that pull. Inside the high court, time compresses. Long arcs collapse into discrete moments. A decade of tension can hinge on one answer, one document, one hesitation. And the judge, it became clear, was now watching those moments closely. Prince Harry had returned to London with a sense of purpose that was visible from the start. Not performative confidence, something quieter. A measured seriousness. He took his seat like someone who understood the significance of being there. No theatrics, no grand statements, just presence. But presence is not proof. The questions began simply enough. Clarifying dates, establishing timelines, revisiting claims that had been made before, not in court, but in interviews, in statements, in carefully framed narratives that had traveled far beyond Britain. The problem wasn't contradiction. Not yet. The problem was specificity. Again and again, Harry was asked to locate his allegations within concrete moments. When did you believe this happened? How did you know? What, precisely, made you conclude illegal methods were used? These aren't hostile questions. They're foundational ones. And for a case alleging unlawful information gathering, they're unavoidable. Harry's answers were thoughtful, careful, but they were also diffuse. There was a reliance on inference, on context, on the sense that patterns existed, even if individual acts could not always be pinpointed. He spoke of feeling targeted, of noticing coincidences that didn't feel coincidental, of information appearing in print that he believed could only have come from private sources. All of that resonates emotionally. Many people listening would nod along instinctively. But instinct is not admissible. The judge interrupted once, then again, not to challenge Harry's sincerity, but to narrow the focus, to separate what was suspected from what was demonstrable, to draw a line between belief and evidence. And this is where the tension began to show, because narrowing the focus is dangerous when a case is built on accumulation rather than singular events. Strip away the pattern, and you're left with fragments. And fragments, no matter how troubling, don't always assemble cleanly under legal scrutiny. You could feel it in the pacing. The questions slowed. The silences stretched. Harry paused more often, choosing words carefully, sometimes circling an answer before landing on it, or not landing at all. "I don't recall" is a phrase courts hear every day. It's not inherently suspicious. Memory is fallible. Time erodes clarity. Trauma complicates recall, but repetition changes meaning. When "I don't recall" becomes a refrain, it stops functioning as an honest limitation and starts functioning as a structural weakness. It invites follow-up. It invites skepticism. It invites, eventually, intervention. And that's when the judge stepped in. Not sharply, not with irritation, but with a firmness that signaled the court's patience had boundaries. He reminded Harry, and, by extension, everyone watching, that the burden of proof lay with the claimant, that allegations, no matter how sincerely held, required grounding. It wasn't a rebuke. It was a reset. From that moment on, the courtroom felt different, less fluid, more angular. The easy rhythm was gone, replaced by something tighter, more constrained. You could sense the recalculation happening not just at the bench, but at the tables below. Harry's legal team shifted in their seats. Subtle movements. A whispered aside. A glance exchanged and held for a beat too long. These are the moments that never make it into transcripts, but matter deeply in real time. Because legal teams don't react like that unless they feel pressure. The opposition, representing Associated Newspapers, remained composed. They didn't need to press aggressively. The structure of the questioning, now reinforced by the judge, was doing the work for them. Their position has been consistent. Denial. Not selective. Not partial. Total. They reject the claim that their journalists engaged in unlawful methods. They argue that what was published was obtained through legitimate means, lawful journalism, and public interest reporting. The burden, therefore, rests entirely on Harry to prove otherwise. And proving otherwise means surviving moments like this. Moments when the court asks, "How do you know?" Harry answered as best he could. He explained his reasoning, his suspicions, his interpretation of events. But the judge wasn't asking for interpretation. He was asking for connection. "Show me the link." And when that link couldn't be firmly established, the room tightened further. This is where the emotional contrast becomes impossible to ignore. Outside the courtroom, Harry's story is expansive. It stretches across years, across institutions, across systems he believes failed him and his family. It's a story about power imbalance, about unchecked media intrusion, about the human cost of relentless coverage. Inside the courtroom, that story has to collapse into evidence packets and sworn testimony. And collapsing a life into exhibits is brutal. The longer the questioning went on, the clearer it became that this was not a matter of catching someone out. No one was springing traps. No dramatic gotcha moments unfolded. Instead, there was a slow, methodical narrowing of scope. A process that can feel suffocating if you're used to telling your story broadly. Harry's frustration was subtle but visible. Not anger, something closer to disbelief. As if he couldn't quite accept that the certainty he felt didn't translate automatically into legal clarity. At one point, he attempted to contextualize his answer by referring to the broader media environment of the time. The judge allowed it, briefly, and then gently pulled him back. "We are not here to assess culture," the judge reminded him. "We are here to assess conduct." That sentence hung in the air longer than it needed to, because it exposed a fault line. Harry's battle has always been framed as cultural as much as legal, a reckoning with tabloid norms, a challenge to an ecosystem he believes thrives on intrusion. But this court is not a forum for reforming culture. It's a forum for adjudicating specific acts, and that distinction matters more with every passing hour. As the day wore on, the strain became more apparent. Harry's answers grew more cautious, his pauses longer. He seemed increasingly aware that every word carried weight, not symbolic weight, but legal consequence. And then came the moment that would ripple outward quietly but decisively. A member of his legal team intervened, not to object, not to argue, but to clarify, to reframe, to gently redirect the line of questioning in a way that suggested concern about where it was heading. That, more than anything else, signaled the shift. Because lawyers intervene strategically, but they also intervene protectively. And this intervention felt less like offense and more like damage control. The judge allowed it, once. But the message was clear. The court was watching not just Harry's testimony, but the scaffolding holding it up. By the end of the session, no one was smiling. No one was visibly rattled either, but the earlier confidence had been replaced by concentration, focus, calculation. This was no longer a day about making a point. It was about surviving scrutiny. And as Prince Harry left the courtroom, the cameras captured something that will likely be dissected endlessly in the days ahead. Not a dramatic gesture, not an outburst, just a moment of stillness. A pause. The same kind of pause that had settled over the room earlier. The kind that signals not resolution, but uncertainty. Because the warning had done its job. It had narrowed the field, raised the stakes, and made it clear that the next phase of this case would demand something different, something sharper, more disciplined, less reliant on belief. What happens when a story built over years is suddenly required to stand on its smallest details? That question now hangs over everything. And with Prince Harry expected back in the witness box again, the courtroom is bracing for answers that may either steady the case or expose just how fragile it has become. What came next would force everyone involved to confront that fragility head-on. Did you notice what didn't happen next? There was no immediate collapse, no explosion, no dramatic pivot that would make for an easy headline. That's how these things usually go wrong. Slowly, almost politely, Prince Harry returned to the witness box with the warning still hanging in the air, the kind of warning that doesn't echo loudly, but changes how every word is weighed. The judge hadn't accused him of anything, hadn't dismissed his case, but the message was unmistakable. From here on, precision mattered more than principle. And that's an uncomfortable place to be if your case is built on patterns rather than pins on a map. The questioning resumed with a noticeable shift in tone. Less expansive, more granular. The court wasn't interested in the totality of Harry's experience anymore. It wanted moments, decisions, mechanisms. The how, not the why. This is where many witnesses begin to feel boxed in, not because they're lying, but because they're being asked to compress years of lived experience into narrow legal channels. That compression can distort things. It can strip away context that feels essential to understanding what happened. Harry tried to push back against that compression. Not aggressively, not defiantly, but by repeatedly returning to the idea of inference. The sense that certain information could only have been obtained through improper means. He described articles that appeared with uncanny timing, details that seemed too intimate, too specific, too aligned with private conversations to be coincidence. The problem is that adaptation itself can be read as uncertainty. And uncertainty, in a case like this, carries risk. At one point, the judge asked a question that seemed simple on its face, almost innocuous. It concerned the source of a particular piece of information that had appeared in print. Harry began to answer, then stopped, looked down, paused. That pause mattered, because it wasn't the pause of someone searching for a word. It was the pause of someone realizing that the answer he wanted to give might not withstand scrutiny. He eventually responded, but the hesitation lingered. These are the moments lawyers worry about, not because they're dramatic, but because they're cumulative. Each one adds a layer of fragility to a case that depends on coherence. Behind the scenes, the legal team's posture shifted again. More note-passing, more whispered exchanges, less eye contact with the public gallery. They weren't panicking, but they were managing, and management suggests risk. The opposing counsel, sensing this, did not press harder. That restraint was strategic. Overplaying your hand in moments like this can backfire. Better to let the witness speak, and let the court draw its own conclusions. The judge, meanwhile, maintained his steady cadence. He wasn't rushing. He wasn't rushing anyone else either. Time, in that room, belonged to him. As the day edged toward its end, the cumulative effect of the questioning became clear. This was no longer a hearing about journalistic misconduct in the abstract. It was an examination of Harry's ability to anchor his beliefs in demonstrable fact. And that examination was exposing limits. Again, that doesn't mean the case is lost. Courts are not verdict factories that spit out outcomes based on a single day's performance. But momentum matters. Perception matters. And credibility, once dented, is difficult to restore. The most telling moment came not from a question, but from a response. Asked whether he could definitively state that illegal methods were used to obtain certain information, Harry replied carefully, emphasizing that he believed so, based on the totality of circumstances, but acknowledging that he did not have direct proof of the specific methods employed. That answer was honest. It was also dangerous. Because belief, no matter how sincerely held, cannot substitute for proof in a courtroom. The judge did not react visibly. He didn't need to. The implication was already clear to everyone paying attention. This case was now balanced on a knife edge. As the session concluded, the court adjourned without ceremony. No dramatic exchanges. No last-minute motions. Just the quiet shuffle of papers, the rise of the bench, the slow dispersal of tension into the corridors beyond. Outside, cameras waited. Inside, something more significant had happened. The case had narrowed. And narrowing cuts both ways. For Prince Harry, the next appearance in the witness box looms larger now. Every answer will be weighed against the standard the judge has already articulated. There is less room for narrative drift, less tolerance for inference. The warning has teeth. And the question now isn't whether Harry believes he was wronged. It's whether he can show it. What happens when a case that draws its strength from moral certainty is forced to operate within legal uncertainty? That is the question hovering over the courtroom as Thursday approaches. And it's a question that will not go away quietly. Because the next round of testimony won't just test Harry's memory. It will test the structural integrity of the entire case. And if that structure gives way, even slightly, the consequences will extend far beyond this courtroom. What if the most dangerous moment in a trial isn't when someone says too much, but when they finally say exactly what they mean? That's the question hanging over the courtroom as Thursday approaches. Not because anyone expects a dramatic reversal, but because the margin for error has thinned to almost nothing. After the warning, after the recalibration, the room is no longer listening for a story. It's listening for seams. Harry knows this now. You can tell by the way his answers have changed. Shorter, more contained, less willing to wander into context and less invited. This isn't a loss of confidence. It's the posture of someone who understands the rules have shifted and is trying to adapt in real time. The problem is that adaptation itself can feel unnatural, especially when the case you're making is not about one act, but many. Not about a single intrusion, but an accumulation of them. Courts are uncomfortable with accumulation. They want instances. They want exhibits. They want lines you can draw with a ruler. And as the questions resume, the court starts drawing those lines itself. The judge begins by narrowing the lens even further. Specific articles, specific dates, specific allegations. The sprawling narrative of media intrusion is now being segmented into manageable units, and each unit is being tested for strength. This is a subtle but profound shift, because when a judge segments a narrative, it's often to see what stands on its own. Which parts are structurally sound, which rely on neighboring claims to remain upright. Harry responds carefully, but the segmentation exposes something uncomfortable. Many of his conclusions are relational rather than evidentiary. One article feels connected to another. One disclosure feels linked to a previous intrusion. Together, they form a pattern that makes sense to him. But when separated, some of those links weaken. This is not an accusation of fabrication. It's an illustration of how human experience works, and how legal analysis doesn't always accommodate it. The court presses on. At one point, Harry is asked to explain how a journalist would have obtained a particular detail without unlawful means. He offers possibilities, informed by his understanding of how the press operates. But possibilities are not mechanisms. They're hypotheses. The judge listens, nods once, and then asks the question again, slightly rephrased. How would they have done it? That rephrasing matters. It strips away inference and asks for process. Harry pauses. This is one of those moments that doesn't look like much if you're not attuned to it. A pause can be dismissed as thoughtfulness, as care, as caution, but in this context, it functions differently. It signals a gap, and gaps invite conclusions. The judge doesn't rush to fill it. He allows the pause to exist, allows Harry to answer in his own time. But the longer it stretches, the clearer it becomes that the answer isn't coming easily, not because Harry is evasive, but because the mechanism he's being asked to describe may not be something he can concretely demonstrate. This is the quiet danger of relying on lived experience in a legal setting. Experience tells you something is wrong. Law asks you to show exactly how. The legal team senses the tension immediately. They don't interrupt. That would only draw attention. But their posture changes. One lawyer leans forward slightly. Another flips a page that doesn't need flipping. These are not random gestures. They're tells. The opposing counsel notices too. But again, they don't press. They don't need to. The court is doing the work. The judge moves on, but the effect lingers. As the testimony progresses, a pattern emerges, not of deception, but of displacement. Harry's strongest statements are emotional truths. His weakest are procedural ones. The court, however, privileges procedure. This creates a kind of dissonance that's difficult to resolve mid-testimony. Harry isn't being disbelieved. He's being asked to translate. And translation is risky when the source language doesn't map cleanly onto the target one. At one point, Harry attempts to anchor an allegation by referencing broader industry practices that were exposed years ago. The judge allows the reference, then draws a clear line. General practices do not establish specific acts. It's said calmly, almost kindly, but it lands with force. Because it means that history, the thing that gives Harry's claims so much weight in the public imagination, is now functionally off the table. Not irrelevant, but insufficient. The room feels tighter again. This is where witnesses often become defensive, or frustrated, or overly careful to the point of paralysis. Harry does none of those things. Instead, he becomes quieter, more deliberate, less expansive. That restraint is admirable. It's also revealing. It suggests an awareness that every additional word is a potential liability, and that awareness changes the energy of the testimony. Questions that might once have been met with confident elaboration now receive narrow answers. Clarifications are given only when asked for. The narrative voice that has defined Harry's public engagement with this issue is subdued, not silenced, but contained. The judge notices. At one point, he asks whether Harry feels constrained by the format of the questioning. It's a rare moment of acknowledgement, a recognition that the process itself can feel limiting. Harry answers honestly. He says that the format does make it difficult to convey the full scope of his experience. That reducing years of intrusion to isolated questions can feel misleading. The judge listens. Then he responds. This court deals in specificity. That's it. no elaboration, no debate. And in that moment, the philosophical gap between Harry and the legal system becomes unmistakable. Harry wants the court to understand the environment, the culture, the cumulative harm. The court wants to know who did what, when, and how. Neither position is unreasonable, but they are not aligned. As the session continues, the judge issues another clarification, not quite a warning, but a reinforcement. He reminds all parties that conjecture, even informed conjecture, cannot substitute for evidence. This is the second time the word appears. Evidence. It lands harder the second time, because by now, it's clear that the case is orbiting that word without fully landing on it. Harry's legal team makes another intervention, subtle, measured, to reframe a line of questioning. The judge allows it, but with a caveat. The witness must answer directly. That caveat matters. It tells the room that patience is thinning, not because anyone has misbehaved, but because the court senses a risk of drift, and drift, in a case like this, can erode clarity beyond repair. By the end of the day, the cumulative effect is unmistakable. Harry has not imploded. He has not contradicted himself dramatically. He has not been caught out in any obvious way. But the structure supporting his case has been stress-tested, and some of the beams are flexing. Outside the courtroom, coverage will likely focus on surface-level moments, on quotes, on perceived demeanor, on whether Harry appeared confident or shaken. But inside, the real story is quieter. It's about the narrowing of acceptable answers. It's about the transition from a case powered by moral certainty to one constrained by legal exactitude. And it's about what happens next. Because the judge's posture suggests that the court is no longer willing to accommodate broad framing. The next phase of testimony will require sharper answers, or will expose the absence of them. That's the risk now. Not that Harry will say something wrong, but that he will be unable to say something right in the way the court requires. As Thursday looms, the stakes are no longer abstract. They're procedural, tactical, immediate. They'll arrive quietly, in rulings that narrow claims, in findings that limit scope, in judgments that turn on technicalities rather than narratives. This is the point in a trial where momentum can slip without anyone noticing, until it's too late. And as the courtroom prepares to reconvene, one thing is clear. The space for ambiguity is shrinking. What comes next will determine whether this case stabilizes, or whether the warning issued earlier becomes something much more consequential. What happens when the room stops asking questions and starts measuring answers? That's the shift no one announces, but everyone feels. By the time the court reconvened, the atmosphere had hardened. Not hostile, not dramatic, just set. The kind of environment where the rules are no longer being explained because the expectation is that everyone now understands them. Prince Harry took the stand again with the awareness of someone walking onto narrower ground. You could see it in the way he settled himself, in the way he waited for the question to finish before answering, as if anticipating the trap that wasn't there, but might be. The judge didn't open with a rebuke or a reminder. He didn't need to. The previous sessions had already done the work. The tone now was one of evaluation, not exploration. And that distinction matters. Exploration is generous. Evaluation is not. The questions resumed, and they were quieter now, less explanatory, less patient. The court was no longer trying to understand Harry's story. It was trying to test it. One of the first things the judge did was return to an earlier answer. Not to contradict it, but to refine it. A detail Harry had mentioned in passing before was now being isolated and examined on its own. This is a classic courtroom move. When a judge circles back to something you thought had passed, it's rarely accidental. Harry answered again, slightly differently this time, not in substance, but in emphasis. He clarified a phrase, narrowed a claim, pulled back from a certainty he had previously expressed with more confidence. It was subtle. But subtlety is everything at this stage, because consistency is one of the few currencies a witness has. And inconsistency, even when innocent, creates friction. The judge didn't accuse him of changing his story. He didn't point it out explicitly. Instead, he asked a follow-up question that forced Harry to choose between two interpretations of his own earlier statement. That's a hard place to be, because choosing means excluding. And exclusion, in court, can look like retreat. Harry chose carefully. He framed his response in terms of perception rather than fact, of belief rather than knowledge. It was honest. It was also revealing. This is the point in proceedings where legal teams start to worry less about what's being said and more about what's not being said. The absence of definitive mechanisms. The lack of hard documentation. The reliance on inference. None of this invalidates Harry's experience. But the court is no longer assessing experience. It's assessing proof. The opposing counsel began to engage more directly now, not aggressively, but precisely. They returned to the core of their defense. Denial. Not rhetorical denial, but procedural denial. They emphasized that the information published could have come from lawful sources, from public records, from third parties, from legitimate reporting practices. They didn't need to prove how the information was obtained. They only needed to show that Harry couldn't prove it was obtained illegally. That asymmetry is crucial, and it's one many claimants underestimate. At one point, Harry attempted to argue that the improbability of lawful acquisition was itself evidence, that the consistency of certain details appearing across articles suggested a deeper intrusion. The judge listened. Then he asked a question that landed like a pinprick. Improbable is not impossible, is it? Harry paused. He acknowledged that it wasn't. That acknowledgement mattered, because it conceded the logical space the defense needs to operate in. As long as lawful acquisition remains possible, not proven, just possible, the burden remains unmet. The courtroom didn't react outwardly, but internally, that concession reshaped the landscape. This is the slow erosion that happens in real trials, not through dramatic collapse, but through incremental narrowing. Each answer that retreats just slightly from certainty creates more room for doubt. The judge continued to tighten the frame. He asked Harry whether he had ever seen direct evidence of illegal methods being used against him by journalists working for the publisher. Harry answered truthfully. No, he had not seen such evidence directly. Again, an honest answer. Again, a dangerous one. The judge didn't comment. He simply moved on. But the effect lingered. Harry's legal team shifted again. Their interventions became more frequent, though still restrained. They sought to contextualize answers, to emphasize cumulative impact, to remind the court of the broader environment in which these publications occurred. The judge allowed context, to a point, but each allowance came with a boundary. We are not trying the press as an institution, he said at one point. We are examining specific allegations. That line is more than procedural. It's philosophical. Harry's case is, at its core, a challenge to a system. But the court is designed to adjudicate actions, not systems. This mismatch is becoming impossible to ignore. As the testimony wore on, the judge's patience remained intact, but his tolerance for ambiguity did not. He began to interrupt more often, not to scold, but to redirect, to cut off answers that drifted into narrative when the question demanded specificity. This is not a sign of hostility. It's a sign of closure. When judges sense that a line of questioning has yielded what it's going to yield, they move on. They stop giving witnesses space to elaborate because elaboration no longer adds clarity. That moment may have arrived. Harry's demeanor reflected this shift. He became more inward, less expansive. His voice softened. His sentences shortened. Again, this isn't weakness. It's awareness. But awareness doesn't always help. In some cases, it magnifies the constraints you're operating under. One exchange near the end of the session captured the tension perfectly. Harry was asked whether he could identify a single article, a single instance, where he could definitively state that illegal information gathering had occurred. He named one, cautiously. He explained why he believed it met that threshold. He outlined the circumstances, the timing, the nature of the information disclosed. The judge listened carefully. Then he asked one question. What evidence supports that conclusion? Harry hesitated, not because he hadn't thought about it, but because the answer, once again, relied on inference rather than documentation. He explained his reasoning. The judge acknowledged it, and then he moved on. That movement spoke volumes, because it suggested that the court had heard this reasoning before and found it insufficient. As the day drew to a close, the sense of compression intensified. The room felt smaller, the margins thinner. Everyone understood that the next phase of testimony would not be forgiving. Outside, commentary will frame this as a clash between a prince and the press, as a symbolic battle over accountability, as a referendum on tabloid culture. Inside, the court is focused on something far narrower. Can this case survive without direct proof? That's the question now. Not whether harm occurred. Not whether the press can be cruel. Not whether Harry's experience was real, but whether the law can act on it. As the judge adjourned the session, there was no sense of relief. Only anticipation, the tense kind. The kind that comes when a process has reached a critical threshold. Because if the next round of testimony fails to produce something new, something concrete, the court may begin to limit what remains in play. And when courts start limiting cases out, that movement is telling. The legal team's posture changes again. Less note-passing now. More stillness. This is what recalibration looks like when options narrow. Not panic. Not desperation. Just a quiet recognition that the room is no longer receptive to certain arguments. Opposing counsel begins to emphasize something they've barely needed to say out loud until now. Possibility. They don't need to prove how information was obtained. They only need to show that lawful routes existed. That public records, social circles, third-party leaks, or legitimate reporting could explain the disclosures. They ask Harry whether he can exclude those possibilities. He cannot, and he doesn't try to pretend otherwise. That honesty is admirable. It's also consequential. Because the moment you acknowledge lawful alternatives, you reinforce the asymmetry at the heart of the case. The defense needs possibility. The claimant needs proof. The judge doesn't react outwardly, but he begins to ask fewer questions. That's another signal. When judges start asking fewer questions, it often means they've reached a working understanding of the case's contours. They're no longer gathering information. They're assessing weight. Harry continues to answer, continues to clarify, continues to walk the narrowing path he's been given. But the energy is different now. Earlier, there was a sense that the testimony might still turn something up, that a crucial detail might surface, that a line of questioning could unlock something concrete. Now, the room feels like it's waiting for the inevitable end of the exercise. Not the end of the case, but the end of this phase. One exchange captures the moment perfectly. Harry is asked whether he believes journalists acted maliciously or opportunistically. He answers thoughtfully, acknowledging that he can't speak to individual motivations, but that the effect on him was the same regardless. It's a humane answer. It's also not what the court is asking. The judge interjects, gently but firmly, to remind him that motive is not the issue here. Conduct is. That correction lands quietly, but it sharpens the divide once more. Harry's experience is framed in terms of impact. The court's analysis is framed in terms of action. Those frames are no longer overlapping. As the testimony continues, the judge begins to signal time constraints. Another subtle cue. The court is preparing to move on. Harry's legal team attempts one final repositioning. They reference the broader context again, not to argue it outright, but to remind the court that patterns have been recognized in other cases. The judge listens, then responds with something that sounds procedural but carries weight. Each case stands on its own. That's the third time a boundary like this has been reinforced. At this point, repetition becomes instruction. By the end of the session, there is no sense of collapse. No dramatic unraveling. Harry remains composed. His answers remain careful. No contradictions explode into view. But something else has happened. The oxygen has thinned. The case feels smaller now. More constrained. Less flexible. That's not how high-profile legal battles are supposed to feel, at least not in the public imagination. We expect escalation. Fireworks. Turning points that announce themselves. What's happening here is quieter. More procedural. And in many ways, more decisive. Because courts don't need drama to make decisions. They need sufficiency. And sufficiency is what's being tested now. As the judge adjourns, his demeanor suggests a man who has seen enough to begin forming conclusions, even if those conclusions won't be articulated for some time. Harry stands, gathers his papers, leaves the room without ceremony. Outside, the narrative will continue to churn. Supporters and critics will read meaning into every gesture. Headlines will speculate about confidence, about strategy, about momentum. Inside, the process has moved into a different phase. The phase where judges stop asking what happened and start asking what can be proven. And that shift, once it occurs, is irreversible. The next steps in this case won't be about expanding the story. They'll be about narrowing it. And when cases narrow, they often reveal truths that are less satisfying than the narratives that brought them to court. The question now isn't whether Harry has a story worth telling. It's whether the law has room to act on it. That question will shape everything that follows. By now, everyone understands the unspoken rule in the room. No one says it aloud, but it governs every exchange. There will be no more generosity with uncertainty. That shift doesn't arrive with drama. It arrives with economy. Fewer words, shorter questions, longer silences. The court is no longer exploring what might be true. It's weighing what can survive. When Prince Harry takes the stand again, there's a noticeable stillness about him. Not tension exactly. Something closer to concentration. The kind that comes when you know every sentence is now a test, not a conversation. The judge begins without preamble. He asks about a specific allegation that has been hovering in the background for days. One that, until now, had been treated as part of a larger mosaic. Today it's isolated, placed under a light, examined on its own. Harry answers. He explains why he believes this particular incident crosses the line. He walks through his reasoning step by step, careful not to overstate, careful not to speculate beyond what he can justify. It's a disciplined answer. But discipline, at this stage, can feel thin. The judge follows up with a question that narrows the frame further. It's almost surgical. He asks Harry to identify what distinguishes this incident from others. What makes it demonstrably unlawful rather than merely intrusive? Harry pauses. This pause is different from earlier ones. It's not searching. It's weighing. You can almost feel him deciding which words to let go of, which to keep. He answers by pointing again to improbability, to timing, to the sense that certain information could not have been obtained legitimately. The judge listens. Then he says something that sounds procedural, but isn't. Improbability invites suspicion. It does not establish fact. That sentence doesn't accuse. It doesn't dismiss. It clarifies. And clarity, in court, is often the most unforgiving thing. From here on, the questioning feels less like an exchange and more like a calibration. Each answer is being measured against a standard that has now been made explicit, and that standard is exacting. Harry is asked whether he has contemporaneous records supporting his belief. Notes, communications. Anything created at the time the articles were published that would anchor his suspicions in real-time documentation. He answers honestly, no. He explains that at the time, he didn't know how information was being obtained, only that it felt invasive. That the full scope of potential wrongdoing became apparent later, after public revelations about media practices. This explanation makes sense. Many people only recognize harm after patterns emerge. But recognition after the fact doesn't always translate into admissibility. The judge nods once, then moves on. That movement, again, is telling. It suggests the court has heard this explanation before. It understands it, and it has decided how much weight to assign it. As the session continues, the judge begins to summarize Harry's answers back to him. Not inaccurately, not unfairly, but concisely, stripping away nuance, reducing complexity. This is another classic judicial technique. When a judge summarizes your position, he's testing whether it can be compressed without distortion. If it can't, that's a problem. Harry listens to the summary, then gently corrects a detail, clarifies a phrase, adds a caveat. The judge accepts the correction, but the act of summarization has already done its work. It has exposed how much of the case depends on inference rather than demonstration. The legal team senses it. Their posture tightens. They become even more selective about when to intervene. They know that every intervention draws attention, and attention, at this point, is not always an ally. Opposing counsel remains measured. They don't need to push. The structure of the proceedings is doing the heavy lifting. At one point, Harry is asked whether he believes the publisher acted knowingly or negligently. He answers cautiously, acknowledging that he cannot speak to intent, only to impact. It's a careful answer. It's also one that shifts the case subtly, because intent matters in law, and the absence of a clear position on intent complicates the court's task. The judge doesn't challenge him on it, but he notes it. You can tell by the way he writes something down, slowly, deliberately, as if marking a box that has now been checked. As the testimony wears on, a strange inversion begins to take place. Earlier, Harry's emotional certainty filled the room. Now, it's the court's certainty that dominates. Certainty about what it requires, what it will consider, and what it will not. This inversion changes the power dynamic. Harry is no longer shaping the narrative. He's responding to a framework he didn't design and can't alter. At one point, he attempts to express frustration, not with the process, but with the implication that his experience is being reduced to technical insufficiency. He stops himself mid-sentence, rephrases, softens the tone. That self-correction is human. It's also revealing. It shows awareness of how quickly emotion can be misread in this setting, how easily frustration can be mistaken for defensiveness. The judge notices the self-correction. He allows Harry to finish. Then he responds with a sentence that lands quietly but decisively. This court must work with what is presented, not what is felt. There it is again, the line between experience and evidence. It's becoming a refrain. As the session nears its end, the judge signals that he has a final question. The room stills. He asks Harry whether he understands that the court may have to limit the scope of the case if certain allegations cannot be substantiated to the required standard. It's a procedural question, but it carries weight. Harry answers that he understands. That acknowledgement matters, because it signals acceptance of a possibility that would have been unthinkable earlier in the process. That parts of the case may not proceed. The judge nods, thanks him, adjourns. No drama, no spectacle, just finality. As Harry steps down, the atmosphere feels different again. Not tense, not relieved, resolved in a way. This phase is ending. Outside, speculation will swirl. Commentators will debate whether Harry performed well or struggled. Those assessments will miss the point. What happened here wasn't about performance. It was about filtration. The court has begun filtering the case, separating what can be tested from what cannot, what can move forward from what may be set aside. That process is invisible to most observers, but it's decisive, because once a court begins to limit scope, the shape of the final outcome starts to emerge, even if no ruling has been issued. The next steps will not involve broad storytelling. They will involve arguments about sufficiency, about thresholds, about whether certain claims meet the standard required to be heard at all. And those arguments rarely favor cases built on accumulation rather than documentation. This doesn't mean the story ends here. It means the story changes, from a battle over wrongdoing to a negotiation over what can legally be addressed. That shift is subtle, but it's profound. And as the courtroom prepares for the next phase, one thing is clear. The warning issued earlier was not symbolic. It was preparatory. What comes next will determine not just whether Prince Harry's case succeeds, but how much of it survives to be judged. There's a moment after a court adjourns when the noise returns before the meaning does. Chairs scrape, papers shuffle, doors open, voices come back into the corridor. To an outsider, it looks like release, the pressure valve easing, the tension dispersing. But inside the courtroom, something very different has just happened. The case has crossed a threshold, not visibly, not officially, but structurally. Because when a judge starts talking about limiting scope, the story is no longer about who is right or wrong. It's about what will even be allowed to exist inside the legal frame. And that's where this becomes dangerous. Prince Harry understands this. You can see it in the way he leaves the courtroom. Not hurried, not defiant, but deliberate. He's processing. So is everyone else. Because the warning, the clarifications, the repeated narrowing, they weren't isolated. They were cumulative. They were preparatory. The next phase doesn't belong to testimony. It belongs to argument. And arguments about scope are unforgiving. They don't ask whether harm occurred. They ask whether harm can be litigated. That distinction matters more than most people realize. Because once a court limits scope, entire sections of a case can disappear without ever being ruled false. They simply become legally irrelevant, unprovable, inadmissible. That's the quiet risk now. The judge has not said the allegations lack merit. He has not dismissed Harry's experience. But he has repeatedly signaled that the court will not infer illegality from atmosphere, history, or emotional coherence. Only from evidence. So what happens next? Behind the scenes, this is where legal teams earn their fees. The public doesn't see it, but this is the phase where written submissions tighten. Arguments sharpen. Claims are reorganized. Weak limbs are pruned to protect the trunk. And pruning always changes the shape of a case. Harry's legal team now faces a strategic dilemma. Push forward aggressively with the full scope of allegations, risking that the court narrows them anyway. possibly in a way that looks unfavorable, or proactively concede limits, focusing on the strongest, most defensible claims, hoping to preserve credibility and avoid a more damaging judicial cut. Neither option is clean, because narrowing voluntarily can look like retreat. But being narrowed by the court can look like failure. That's the bind. The defense understands this too, and they will exploit it carefully. They don't need to prove innocence in every respect. They only need to demonstrate insufficiency in enough places to weaken the overall structure. This is where asymmetry works in their favor. They can argue possibility. Harry must argue proof. They can point to lawful alternatives. Harry must exclude them. They can remain still. Harry must move forward. And every forward step now carries risk. What's especially striking is how this moment contrasts with the public narrative that has surrounded the case for years. Outside court, the story has been one of certainty, of knowing, of calling out wrongdoing with moral clarity. Inside court, certainty has become a liability, not because it's false, but because it invites challenge. Judges are suspicious of certainty unsupported by documentation. They've seen too many cases built on conviction that collapses under scrutiny. So the court's posture now is cautious, conservative, procedural, and that posture shapes everything that follows. There's another layer here that hasn't been fully addressed yet, but it's looming. Time. The longer this case has gone on, the more distance there is between the alleged conduct and the present moment. Memories fade. Records disappear. Context shifts. Courts are acutely aware of this. Delay doesn't automatically discredit claims, but it complicates them. It raises questions about why evidence wasn't gathered earlier, why certain steps weren't taken at the time. Harry has addressed this partially, explaining that he did not know, at the time, the extent of potential wrongdoing. That explanation is plausible. It's also common. But common explanations don't always carry legal weight. The court may accept why evidence doesn't exist and still require it. That's the cruelty of the process. And it's why so many cases that feel morally compelling struggle legally. Now, as the case edges toward argument rather than testimony, the emotional temperature drops further. This is where legal language takes over, where words like threshold, standard, and sufficiency begin to dominate. Those words don't trend on social media. They don't animate public debate, but they decide outcomes. Harry's role shifts now as well. He is no longer the primary engine of the case. The spotlight moves to submissions, to how his lawyers frame what remains, to which claims they emphasize, which they quietly let go. That shift can feel like loss of control, especially for someone whose public life has involved reclaiming narrative agency again and again. But courts are not interested in agency. They are interested in jurisdiction, and jurisdiction has limits. The judge's repeated reminders about specificity weren't incidental. They were instructions. Signals to both sides about what he will and will not entertain going forward. Ignoring those signals is dangerous. Responding to them requires sacrifice. Some claims may not make it to judgment, not because they're untrue, but because they cannot be tested to the required standard. That's a reality many litigants struggle to accept. It feels unjust. It feels technical. It feels like a loophole. But it's not a loophole. It's the foundation of the system. Courts cannot punish what they cannot define. And definition requires evidence that does more than suggest. It must show. So as the case transitions into this quieter, more consequential phase, the question becomes less dramatic but more decisive. What survives? Which allegations remain intact when stripped of inference, pattern, and retrospective interpretation? Which can stand alone? Those questions are now being answered. Not in public, but in drafts, revisions, strategic meetings held behind closed doors. And the answers will shape not just the verdict, but the narrative that follows it. Because even if Harry ultimately prevails on some claims, the fact that others were filtered out will matter. It will be cited, interpreted, spun. Supporters will say the court was constrained. Critics will say the case overreached. Both will be partly right. That's the nature of cases like this. They don't resolve cleanly. They resolve in fragments. There's also a personal cost here that the court will never address directly, but it's real. Being told, implicitly, that parts of your experience cannot be adjudicated is disorienting. It doesn't mean you're wrong. It means the system cannot engage with you fully. For someone whose grievance is rooted in feeling unheard, that irony cuts deep. But courts do not exist to validate experience. They exist to apply rules. And those rules are now firmly in play. The next step, procedurally, will involve arguments about which claims proceed and which do not. Those arguments will be dense, technical, dry, but their implications are anything but. Because once the scope is set, the rest of the case unfolds within it. Evidence is evaluated against it. Outcomes are constrained by it. And shrinking scope means shrinking possibility. That's why this moment matters more than any dramatic exchange in the witness box. The case hasn't collapsed, but it has been reshaped. Quietly, deliberately, with intent. And as the judge prepares to hear the next phase, he is no longer asking what happened. He's asking what remains.